Hello, everyone. This is Tom Fox back for another episode, and I'm absolutely thrilled today to have Mike DeBernardis. Mike is a partner at Hughes Hubbard and Reed in Washington, and we are going to explore an angle of the failure to prevent fraud offense that I think American general counsels and American lawyers are not really thinking about. And so I posed this to Mike, and he said he's happy to come on, and we're just going to have a conversation. Mike, I was probably one of the worst when this new law was not enacted, but was passed and will be enacted September 1, I'm thinking, fraud. Oh, okay, I get that. Somebody stole money from the company, and now the company's trying to get it back, except they're going to punish the company for an employee stealing money. That's not it at all. And it's the company engaging in fraud. And you and I typically would not say a company defrauded customers, maybe an investor, but we don't think of it that way. So I was wondering if you could maybe explain what you see in the offenses listed, and then how you would sit down literally with a GC, or if you're giving a presentation to lawyers, and say, hey guys, you really need to think about this in a different way.
Yeah, and I think you're not alone in your first reaction to fraud, to hearing fraud and thinking about preventing fraud. I think as we get into it, obviously there are plenty of instances where companies are engaging in fraud, but there is a tendency, I think, when you hear fraud to individualize it, right? You think about a person is a fraudster committing fraud. And as I looked through the offenses, the different fraud offenses under the UK law that could potentially be implicated by this failure to prevent fraud, some of them have very clear equivalents in the US, where when you start to sort of view it in that light, it is easier to kind of conceptualize what we're talking about in terms of the risks for companies. So why don't we start with the fraud by false representation, right? Under the UK, I think this is Fraud Act, I think it's Section 2, and it's knowingly making untrue or misleading statements to gain an advantage. We will often think about that in terms of a individual, right? There's very similar parallels in the US, making false representations to obtain property or money. Often those are charged in the US, as many of these, under very broad statutes such as wire fraud and mail fraud, which capture basically all kinds of conduct. But for a company, if you think about that, you can think about all kinds of different ways this could come up, right? You can have, when I was thinking about this, I was thinking about employees who are making false representations to earn business, right? To potential customers or to customers to earn business. You have situations, and there's a lot of different ways you can spin that. You can think about kind of a Wells Fargo aspect to that case. You've got situations where you might be making your company, or an employee for the company might be making a false representation as part of a competitive tender process, maybe inflating its credentials for part of a tender process. So there's absolutely this sort of corporate angle to that offense that I think is really often overlooked, to your point, especially for US companies, when we're thinking about potential risk exposure, because the jurisdictional hook here is very broad. As when clients have asked me about it, and I'm not an expert in the failure to prevent fraud, but what I do know is that jurisdiction is very broad. If you have operations in the UK, you're potentially exposed. Or I think importantly here, if there's victims of the fraud in the UK, you are potentially exposed here. So thinking about it along those lines of, all right, under the US, there's these very broad fraud statutes. Companies often can bump into them. And now there's this exposure in the UK it's basically an additional pain point if you find yourself facing an allegation of fraud, or an internal or external.
Mike, that really opened my mind with that. And I was practicing on the civil side of things, did a lot of tort litigation. And from time to time, you would get a case which was under the rubric of tortious interference with business relations. And it just struck me listening to you that a UK company could avail itself of that concept if a U.S. company wrongfully takes business from it and maybe even elevate that to something the Serious Fraud Office would consider on a criminal offense, because it's, let me see if I can pull up the language of the statute, it's fraud by false representation. If you make false representation to a third party to get business from them and you've taken business away from another party, perhaps that falls under this rubric. And to me, that could, given the current economic wars that are going across the globe, the UK could weaponize that against companies from countries. It didn't particularly.
Yeah, at the risk of getting too deep into the geopolitics here, with the recent revised FCPA guidelines, there's some worry that the US will weaponize the FCPA to protect US companies competing internationally with companies from other countries. We're gonna use the FCPA to prosecute, for example, a UK company who's perhaps engaged in some sort of corruption in competition with the US company. I can see, in theory, that dynamic being flipped on its head with this. If you think about it, and frankly, you don't even need corruption in this case. Now we're talking about misrepresentations of various kinds. I think the bar is lower. If the UK were to go that direction, the bar is lower to sort of alter the competitive landscape for UK companies.
What about the next offense listed, Mike?
Yeah, so I kind of put this in the same bucket. If we're talking about, so Section 3 is fraud by failing to disclose information. So if Section 2 is kind of knowingly making a false representation, Section 2 is knowingly not saying something you need to say. In the US, we've got fraudulent concealment, concealing material facts in financial transactions. So this comes up, I think, fairly frequently for companies, especially when you're talking about financial statements, financial transactions, documents with various financial institutions where we need to disclose some facts and we don't. Bank fraud is the concept I would equate this to. Again, mail and wire fraud in the US. But we're talking about something that comes up fairly often, and usually companies have protections in place for this type of thing. There is controls to when we are submitting materials to a financial institution, when we are submitting materials to the investing public, we're very careful about what we put in those. We are vetting decisions very carefully about materiality and whether things need to be disclosed. But again, so I think complying with this aspect is not going to be new to companies. But it is adding an additional pain point if something were to go wrong, right? If you've got potential financial institutions in the UK involved in a transaction, now you've got potential exposure under failure to prevent fraud. In broader sense, if you have investing public in the UK and you're violating this, there's potential exposure there too. Again, for this one, conceptually, I think it's not going to become a surprise to US companies, but we're making it far more complex to deal with the fallout.
And I guess the thing I would add is, if I could take our listeners back to the electric truck company, Nikola, which had a semi that they said was fully electric, fully functional, and they had a great video of it going down the road. What they didn't tell us was it was in neutral, not running, and it was going downhill. And that's not a document, that's not a financial statement, and yet the former CEO was convicted of fraud over that criminally. Now, pardoned by President Trump. But it struck me that the company could have gotten in trouble under this offense in the United Kingdom if the jurisdiction had been correct.
Yeah, that's right. Something exactly like that. Those types of fraud. I think this is going to come up most often when you're talking about investing public and financial institutions. Is just that's where you have a lot of obligations under various laws to be honest with the information you are disclosing.
Mike, the next two seem to focus a little more on individuals. So I wanted to maybe ask one if you thought that was down the right track. But number 3 in Section 4 was fraud, abuse of position. And then in Section 11, obtaining services dishonestly. What do you see in those two?
Yeah, we're really talking about honest services fraud there. So I think you're right. I will say obtaining services dishonestly, you can view that could be viewed more broadly, I think. So the fraud by abuse of position, I think that is we're looking at honest services fraud. I think that's going to be harder for a company to run afoul of, although it could certainly come up, and it depends on how broadly that is interpreted under the UK, and I don't know. But obtaining services dishonestly, in the US, the various states have statutes against the theft of services. And a enterprising prosecutor could, in theory, slide various types of fraud into theft of services. If you are, lying or making misrepresentations to get certain services for far under market value, if you're running schemes to get services that you're not entitled to, and this could be services from another party. In theory, at least in the US, you could be charged under some of these state statutes. And so I could see that for this obtaining services dishonestly under Section 11 being interpreted broadly coming into play. It's not, I think you're right, though. I think for these two, we're really probably looking at more individual conduct more conduct you would expect from sort of an individual scammer than you would from a corporation.
Let me see if I can go down a rabbit hole a little bit on dishonest services.
Sure.
I've been interested in this cause of action or this alleged crime since the Enron case, because Jeff Skilling was convicted on this. And one of the arguments his team made was that this is based actually on I'm going to say ancient, but very old English law, which required English servants to give services honestly to their lords or bosses. So literally probably back to the age of Magna Carta. And the argument was that's not appropriate in the 2000s to have that kind of servitude or that requirement. If that interpretation is correct, at least as to English law, and that's still on the books on English law, has this maybe created a new risk and as you've called it, a new pain point for U.S. companies, or is that really something different?
So I think conceptually, sure. And if you're a company trying to assess various risks, that is a risk out there. Whether that is what's intended by fraud, by abuse of position, I don't know. But if I'm running a company and thinking about conduct and whether, what's risky and what's not, I certainly don't want to be just hoping that a law is not going to be interpreted a certain way. I think if I'm designing a compliance program, trying to find out risk areas, and when I'm looking at risk areas, looking at what the potential consequences are, I'm sort of interpreting all of these offenses as broadly as possible for my purposes of assessing risk. And yeah, I think it's possible that this is viewed as honest services in any sort of capacity and relationship. And that's something I'm going to take into consideration when we're looking at possible risks and consequences from these offenses.
Mike, the next actually 4, and I'll just go ahead and read them. We've got participation in a fraudulent business, false accounting, false statements by company directors, and fraudulent trading. Initially, I had thought these are things that American lawyers and general counsels are going to be a lot more familiar with. We might call them something different, but they seem to me to match up pretty closely to current corporate legal obligations and duties. Was there something you saw that a little bit different, or maybe a nuance that we should talk about in any of these?
No, I think if you take them individually, it's hard to find a direct equivalent to all of them, or at least a one-to-one. I think when you group them together, you're exactly right. This group is what we usually think about in terms of securities fraud. FCPA accounting provisions would fit neatly right in here. So violation of the FCPA accounting provisions, falsifying books and records, that would fall kind of under false accounting. Statements to your investors, statements to federal agencies that are false by company directors, that kind of thing. So I think as I was going through this exercise and trying to do a mirroring of each of these frauds, it was hard to come up with a one-to-one. Sometimes there was 2 or 3 statutes in the US that could apply, but grouped together, I think this group of offenses is something where there's equivalents in the US. None of these should be very surprising, I don't think, to a US company or general counsel. I would just add, once again, we're talking about now another pain point. If you reach jurisdiction to the UK, you now don't only have issues with a potential case in the US for violation of the accounting provisions of the FCPA, but you have a potential issue with failure to prevent fraud in the UK.
Mike, the UK government, in the form of the Ministry of Justice, released guidance last November that I thought was helpful. But the kind of second part or I wanted to explore with you on this podcast, would you advocate a CCO or general counsel do some sort of risk mapping exercise so that they know what the risks are? Because what the UK government says is we want to see your policies, procedures, programs, and controls in place to prevent these, to detect it, and then remediate. So could they go through that type of exercise under these different types of fraud, as they might do with anti-corruption or money laundering?
Yeah. Yes, it's a good point. I think in general, U.S. companies should already be doing this. So this type of sort of risk assessment for these frauds, they're not exactly the same. As we've kind of discussed today, there's some nuances between what these fraud offenses in the UK and their equivalents in the US, but they are close enough that the conduct would likely be a violation under both. So if you're a US company, you should already be running risk assessments into this type of conduct, should have policies and procedures and make sure that they're matched up, and do stress testing of those policies and procedures. What I would suggest, and I have suggested, is take a look. It's worth taking a look. Everything is risk-based. Resources are limited. I've been encouraging companies to take a look at their potential exposure. Do you have operations in the UK? Do you have investors in the UK? Are you doing banking there? Do you have offices there? And if the answers to those questions are yes, now take a little bit of a deeper dive into these issues so you can really get to be able to test whether your policies and procedures might be appropriate to fight off a failure to prevent fraud charge. If the answer is no, then you're not free from exposure, but you might want to focus your resources elsewhere. So that the type of risk assessment you describe, I think, is really important. I think the threshold issue for me is do an assessment of jurisdiction and look at your operations. Because I do think when this is enforced, we're going to be looking at, first and foremost, as companies that do have real touch points, whether that's because the fraud was there, because we have serious operations in the country, because we have investing public that was really harmed in the country. So take a look at that first.
Mike, this has been a great exploration of the failure to prevent fraud offense from an angle that, frankly, I don't think we're talking about enough in the United States. And I hope U.S. companies will understand that even if they feel like these are all offenses that we're prepared for here in the United States, each one has just a nuanced difference because it's the United Kingdom and not the U.S. I hope they will prepare for this as they should.
Yeah, absolutely. Thanks for having me, Tom.
Compliance Podcast Network. Start your mornings with daily compliance news, quick, sharp updates on the top compliance and ethics stories in under 5 minutes every morning in Compliance Podcast Network. Because compliance never sleeps. Need practical advice fast? Check out Compliance Tip of the Day. One actionable idea to level up your program. Short and sweet, every day on Compliance Podcast Network. Got 10 minutes? We've got the week's top 10 stories. 10 for 10 brings you the big compliance headlines. Fast, fun, and focused. Every Saturday on Compliance Podcast Network. And don't miss the Sunday Book Review, where compliance meets culture through must-read books and big ideas every Sunday in Compliance Podcast Network. Whether you're in the office, on a walk, or commuting, stay smart, stay ethical, stay tuned. Only on the Compliance Podcast Network. Available wherever you listen to podcasts.